Hello, everyone, and welcome to this Ferrari Council's webinar. It's great to have you all here. Today's webinar, it's called EU Design Reform Unlocked, Protect and Profit from Your Creations. I'm Marta Sierra, I'm Head of Marketing and Communications at Ferrari Council, and I will be your host today. So for those of you who haven't heard about Ferrari Council before, I'm just going to give you a very brief introduction. We are a non-for-profit European research organization that focuses on the link between intellectual property and innovation. To do so, we make sure to choose the most relevant topics, and we collaborate with different institutions, with academics, with IP experts, and of course, other European organizations, such as the EUIPO, which is actually collaborating with us today in this webinar. On our website, you will find our research as well as guides and studies, case law summaries. You will also see that we have an SMEs corner where all the information is tailored to non-IP experts. So if you are new to intellectual property rights, this is actually a really good place to start. We also have a podcast called IP Stories, where we interview startup founders and creators, inventors. You can find it in all the main podcast platforms. We always record our webinars, so if this is the first webinar that you watch from us, just so you know, you can see all the topics that we have covered in the past. You will find all the recordings on the website. And we also have an area called IoT and Cellular Standards Made Simple, where you will find a lot of material on the benefits of standards and IoT across so many different sectors. And we have a brand new section on our website that we just launched called AI and Intellectual Property Rights. Here we have loads of videos and guides and papers on the ways artificial intelligence is changing the way we work and the way we create, and of course also all the raising questions regarding intellectual property rights. So this is a very interesting section, and I invite you all to go check it out. If you would like to follow us, which I encourage you to do because it's the best way to be updated with all the new material that we release and all our upcoming webinars, you can find us on X, LinkedIn, YouTube, and Instagram, always with the same handle, for IP Council. And without further delay, it is my pleasure to introduce our speakers today. They are Elisabetta Ferraro and Frederik Jocqué. Elisabetta is a dual qualified Italian lawyer and UK trademark attorney. She has a background in the private practice, having worked for 8 years at leading IP law firms in Milan, London, and Madrid. She joined the EUIPO 4 years ago, focusing on design-related matters. She is now a member of the Legal Affairs Department, where she leads the knowledge circle design and actively drives the implementation of the Design Legislative Reform Project. Frederik started his career as a trademark and design attorney at Devers in 2011. After having been active in the IP industry for over 10 years, he started in 2022 with Fedustria, the Belgian Federation of the Textile, Woodworking and Furniture Industries, and member of EFIC, as legal counsel and now manager operations. And finally, we have a special guest from the EUIPO, Susanne Hogan, who will very briefly mention at the end of Elisabetta's presentation, the SME Fund for Design Rights. Just before I hand the floor to the speakers, I want to give one final remark to our audience. You will find the Q&A tool at the bottom of your screen. So if you want to submit a question for the Q&A, you need to use that tool, and you can use it at any point. We will take the questions at the end of the presentation, but you can submit your questions at any point from right now. And that's all from me. Frederik, the floor is all yours.
Thank you, Marta, and good afternoon, everyone, from my side as well. My name is Frederik Jocqué, and I have the pleasure of warming you up for this webinar on designs. I will try to do so by talking you through a couple of real case studies. Go to the next slide. Perhaps studies is a bit of a heavy word. It are rather a couple of real-life examples of design cases. And my intention with these real-life examples is to show you the importance of designs and design protection, to show you how it can contribute to the growth and the success of your company, how sometimes things can go wrong as well. And to convince you that design protection is not only for the big corporates and multinationals of this world, but that it is equally or even more important for startups and SMEs. Now, the first real-life example I want to show you is already here on the screen. Perhaps some of you recognize it. It is actually called the egg chair, which is quite an iconic chair, I would say. It was designed in the 50s by a Danish architect called Arne Jacobsen for the company Fritz Hansen. And I wanted to show you this as a real life example because this iconic chair is a very distinctive and has a very distinctive and recognizable shape. And the very short story I want to tell you here is that while today the company Fritz Hansen is a globally renowned design house, you could say, back in the time when they started, they really started as a small carpentry workshop. So they were a small startup SME as well at that time. But throughout the years, they really paid attention to the importance of design protection for this egg chair as well. And it really helped them and contributed to the growth of their company. So this is an example of a success story where design protection has really helped. I take you to the next slide with already a couple of practical tips and tricks, perhaps. I mentioned already that the architect Arne Jacobsen designed this chair for the company Fritz Hansen. So it's important to here to pay attention when you're working together with other people, whereas it are employees or freelance designers. Think already before you start working together with them about having a contract making clear agreements on intellectual property rights amongst which designs. You can even, if you are, for example, a freelance designer yourself, consider to have a non-disclosure agreement or a so-called NDA. It's really good at the outset to already have good agreements. Here on the next slide, you see on the right side, it's actually an extract from the design register from the EUIPO. You can see how today the egg chair is registered as a design. Some things I want to give to you here are, I'm sure Elisabetta will talk about it in a minute, but there are some conditions for design protection, such as novelty. Your design has to be new in order to be registered. And you need to pay attention to this. You will see in a minute why, because sometimes it can go wrong here as well. But here it is really important to know that it is you need to register your design early in the process in order to not to have any problems with this condition of novelty. You could say, okay, I understand why I need to do this, but I don't want my competitors or other parties to already see my design before I go to the market, right? There are solutions for this as well. It's called the option, so-called option of deferment. So you can already apply for your design registration, but not have it published yet. So that's an option. Maybe a good thing to know as well is that the conditions of protection I'm talking about, novelty, there's also something called individual character. They are not, correct me if I'm wrong, Elisabetta or Suzanne, but they are not checked by the office because it's impossible, right? You cannot check every design that has ever been published around the world. So if you meet the formal requirements of design protection, you get your registration. And even though perhaps this design registration is not as strong, you already have something in your hands to defend yourself if necessary. So that's something I think it's good to know as well. The registration or the protection under this registration is limited in time. This is important to know as well. In most countries in the EU as well, your design registration is valid for 5 years. and you can renew it up to 4 times, so 25 years, but then that's it. So keep that in mind depending on the type of your product. If you need to look at design registration and perhaps other types of IP rights as well, such as I mentioned here, you have also unregistered designs and even copyright that can be useful at times. If I go to the next slide, I'm going very briefly a bit off topic or out of scope of this webinar, but when you are starting as an SME, consider trademark registration as well. You can have a new product with a beautiful design. Look at design protection, but don't forget to, if you have a good name or logo, don't forget to register that as a trademark as well. And you see here example on the right side again for the egg chair, how it is today registered with the EUIPO as a trademark. Do it early enough in the process. And also don't forget that trademark registration is not the same as domain name registration. On the left bottom, you see an example. If you go, it's a bit small, but if you go to theegg.com today, you see that this is not the chair you see. So it's a website from another company. So perhaps, I don't know the background, but perhaps they were too late. So think about that early in the process as well. Going back to design, the second real-life example. I'm sure most of you recognize these shoes, I should say, as well. And so these are so-called Crocs. Why am I showing this to you? It's an example actually of how things can go wrong as well. The pictures you see here are how Crocs filed their design for the shoe with the EUIPO at the time in 2004. And it was actually registered then in 2005. However, what was the problem here is that Crocs, the company itself, already disclosed the design of their shoe on their own website and in a trade fair already in 2002. So 2 years before they filed the application for design protection with the EUIPO. So actually, I won't bore you with the legal details, but the bottom line is that they damaged their own condition of novelty for having design registration. So there were quite some legislation, but in the end, the General Court established that the registered community design called at the time was finally invalidated. So keep this in mind. Even big companies can be mistaken, as you can see here. And a third example I want to show you, let's say as a warm-up, are these things. I'm sure most people, depending on the average age here in the room, will recognize these as well. These are so-called pogs. There are different names for it, pogs, milk caps. I've seen some other names as well. They were, I think, mostly in the 90s, a big thing. It's, let's say, a children's toy, and it was a collectible item. Now, what was the case here, and this is the final message I want to bring to you, is it's not because you're a startup or an SME that design protection is not important or that it is only for the big companies. It's the story of David versus Goliath, you could say. This was actually one of the first landmark cases on designs of the Court of Justice. And what happened here? There was on the left-hand side a Spanish company called Grupo Promer. I didn't know this company. I think a lot of people here don't know it. You can still visit their website, but you will, with all due respect to them, see that it's not a big company. But at the time, as you can see here in 2003, they filed this design for a POC in Spain. And what happened is that very shortly after, you have this big player we all know, of course, PepsiCo, who filed a similar design application also in Spain, not even 2 weeks after, so on the 23rd of July in 2003. And again, here I won't bore you with the details, but in the end, it was Grupo Promer, so David in the story, who was successful and was able to win the case from PepsiCo. So again, this is an example of even though you are a small company, take care of your design protection, and then you can really win it if necessary. So that was the messages I wanted to bring to you. and I'm happy to give the floor now to Elisabetta.
Well, thanks a lot, Frederik. Honestly, those are a very interesting example. So I think that now the question is automatic for everybody, for us and people in the audience. Are you making the most of your design rights? Or perhaps maybe we can say, are you protecting your design rights at all? No, because actually this is something that we note anytime that we go outside, we talk to users. We always find that people are kind of disbelief when we say that registering their design at the EUIPO is not only easy, but it's also cheap, very quick, and have lots of advantages. And what Frederik said is an example of this. So during this session, during my presentation, I would like first to quickly just show you how to register a design at the EUIPO. And then we will see together the changes brought about the recent EU legislative reform, which will offer new opportunities to anyone, and it's important to understand how to take full advantage of the system. So let's move on. And to put ourselves into this exercise, just let's imagine for a moment that you are a designer of furniture, for example, and you came up with the idea of a bench. But this is not an ordinary bench, because this is a bench which can flip on either side. I am biased here because this bench is the EIDO bench, which was designed by a Hungarian female designer, and she was a finalist at the Design European Awards in 2016. And here at the EUIPO, we're very lucky because we have a few examples of this bench at the entrance. So imagine that you came up with this idea and you say, I have this product which has a beautiful design, a unique design. So how to protect it? First, how to protect it against copy, direct or indirect copy, against identical copies or also similar copies, for example, or how to take advantage of this design by licensing it, for example, to other people so that you can make a profit. All these things comes with registration. So let's see together how you can register designs at the EUIPO. You may know that if you file one single registration application at the EUIPO, you have a registration which is valid in all the 27 member states. So it's very easy because you file one application and in principle you get protection in 27 places at least. And how does it work? Basically, when we receive the application, there is the examination period, and we perform a substantive check of the requirements. As Frederik said before, design is valid as long as it is new and it has individual character. But actually, we don't check these things at the time of filing. When a design is filed, we only check two things. If it corresponds to the definition of design, so for example, you can't file your picture and say, I want to have this registered as design, because the picture displays your features and you are, I imagine, a human person. So a design cannot exist for living organism. So first thing, we check if the design, the representation that we see corresponds to the definition of design. And second, we check that the design is not contrary to the public policy or morality principle. And then once we have performed this check, immediately we register. And this happens in only 24/48 hours. So I want to say it because sometimes one thinks, oh, I have to register my design, it's going to take long. No, it's very quick, it's very easy because we check just two things, and you have a design which is valid, as Frederik said earlier, for 5 years at least. And if you want to renew it, you can renew it for a period of 5 years up to a maximum of 25 years. And this is also cheap, because if you see how much this is going to cost, you see that registration and publication, which are the fees that you have to pay, are 350. Then there are other fees for multiple applications. Multiple application is like a package, no? You file one single application where you can include more than one design. So it's very convenient because you have a discounts for all the extra designs that you want to include in your application. But this is going to change with the reform. So I will develop a little bit more later on. So the takeaways from this part is just that registering at the EUIPO is easy, is quick, and then you have something tangible that you can use. For example, if you want to go to a trade fair to display your design, or if you want to talk to potential investor, protect yourself, think about it, file immediately your design, and then you can go on the market with something, with some protection. Now, with this thing said, now let's see what are all the changes brought by the design legal reform. There are different things that will happen soon. I want to say a little bit something about the when these things are going to change, because not everything will start at the same moment. Some changes will start already next month on the 1st of May 2025, like the changes in the fees that we will see later. Then there are other changes that will happen as July next year. And then finally, member states have time to transpose all these changes into the national law until the end of 2027. So I won't say anything more on this. If you have questions, you can ask me during the Q&A section, but just for you to know that not everything will start at the same moment. And now let's move on to the why. Why do we have a design legal reform? Why do we need it? These are the main objectives of the reform. First of all, adapting the system to the digital age, then enhancing clarity and protection, and of course, simplify and harmonize the system of the EUIPO with that of the other IP offices. So let's start with the first one, adapting to the digital age. When we talk about designs in general, we talked about the appearance of a product, of something. But as we said, you are a designer, you have the bench in mind, so you develop it in different way. So imagine that you have a yellow taxi in mind, no? And you want to develop your design of a yellow taxi. You can create it as a toy, and the typical toy that children use to play. Or maybe you have in mind something else, like a graphical user interface that we use in WhatsApp, for example. Or maybe you have a yellow taxi in mind that you want to use as a drawing for a t-shirt. Or maybe it's just a character that you want to use for a video game. So all of these are development of the same concept of the yellow taxi, and potentially they can all be designs. And a good system, a system that works, allows to the user to protect all these developments of the same concept and to register them as designs. But before the legal reform, with no doubts, you could register the toy, the logo that you see on the t-shirt, with some interpretation also the graphical user interface. But what about the animation? That wasn't contemplated. And we also have to think that when the design package started and was there in the market, it was in more or less 2002. So we are talking before all the internet evolution that we had. I was checking earlier, and the first iPhone was released in 2007. So this is why more of the definition and the concept of designs that we have now weren't included in the previous system. So Here, the first why and the first answer to this reform, adapting the system to the digital age. And to do so, we have expanded the definition. Now we have a definition of designs, which is the appearance of a whole or part of a product, including, as you can see in the addition in red, including movements, including transition or any other sort of animation. And what is a product? It has been confirmed that a product is an industrial or handicraft item, regardless of whether it is embodied in a physical object or materialized in a digital form, meaning that you can have in mind a toy for a yellow taxi, and that is a product, a tangible product. But if you have in mind the video game, that is a virtual product, and you should be able to protect that. And with the new definition of design, you can. So moving on to the other objectives, enhancing clarity and protection. Now, finally, we have a design notice, which is a very good news for all designers, because as it happens for trademarks, for copyright, now we have a notice for design. So if you have a registered design, you can put this notice there. We have a working group at the EUIPO at the moment trying to understand how to place the notice for virtual products, for example. But this is going to be very interesting and a possibility that we will reveal once we have more information. Then we have expanded the list of rights and limitations. Rights, because we are talking about virtual worlds, no? And let's think about another phenomenon, about 3D printings. Fascinating business. If you have a special machine, you can scan a shoe and you can extract the design incorporated into that shoe. So you have a code that you can upload, then share it with other companies, share or sell it to other companies. And if they have the right machines, then they can download this code and reproduce a product which has exactly the same design as the original one. So if you think about all this process, we are talking about passage of a software, which maybe they don't even have the representation of the design. So that was scary for design owners. When we mentioned all this possibility, they said, okay, but in this case, we are improving copy, that it will be very easy. But actually, in the new regulation, the list of rights has been expanded. So now it's clear that also creating, downloading, copying, sharing, or distributing a software, including the design, representation of the design, is something that the design owner can prohibit. And of course, to compensate for this expansion of rights, there is also an expansion of limitation. So it is possible to use someone else's design for the purpose of comment, critic, parody, or for referential use. And as you can see on the screen, someone used a Lego toy brick, which is a registered design, just to make a parody of Trump. And this is a legitimate use of someone else's designs. Moving on, going towards simplification and harmonization. Simplification, we have tried to simplify as much as possible all the procedures related to the registration of designs. One of these is the unity of class requirements. I mentioned when we were checking the fees that there is the possibility of filing a multiple application having more than one design in it. So up to now, it is possible to use this possibility only if the designs in the multiple application belong to the same class of the Locarno classification. So for example, if you check the screen, you can have in the same class multiple application, you can have the two seats, the armchair and the sofa, because they pertain to the same class. But for example, you can't have in a multiple application the pictures including the frame, because they pertain to different classes. Now with the reform, this is not a limit anymore, because you can file whatever you want in the same multiple application, benefit of all the advantages that it conveys. So you can have all the images, all the objects that you can see on the screen in one single class. And there is just one limitation, which is the maximum number of design that you can have in a multiple application, which is 50. And that it's a huge form for simplification, because we had lots of deficiencies because of this lack of unity of class requirements. And then we are trying to harmonize our procedures with trademark procedures, so that the users can learn just one system and then apply all the rules to everything. And also our rules with that of national intellectual property offices, exactly for the same reason. What you do at the EUIPO should be available also at the national level. And finally, on the fee levels and structures, this is the same table that we have seen at the beginnings. And now, as from May, we will see some changes. As we have tried to simplify also in terms of fees, because as you see, first we had one fee for registration and one fee for publication. Now, the amount is the same, but you pay just once, one fee, 350, which already has inside registration and publication. So you don't have to think I have to pay twice, but it's already there. Then for multiple application, there are been some changes, because the first design in the multiple application is always 350. And then you have, in the past, you had a huge discounts as from the 11th design onwards. Now all the design in a multiple application from number 2 to number 50 cost 125, and there aren't the fee for publication anymore. And there has been an incrementation of fees for renewals, but in any case, this will happen after the first 5 years. But good news is that there are some funds. And here I will leave the floor to my colleague, Susanne, and she will tell you more about this.
Hi. Thank you, Elisabetta. It's a really interesting presentation both of you have given, actually. Yes, so on one hand, you're talking about Frederik started, and Elisabetta, you also reminded us how important it is. It's by protecting designs, it's the only legal protection that you can have. And then Elisabetta pointed out how actually simple it is and quick it is to register. And then, of course, the other big worry that always comes to people's head is, yeah, but it's a lot of money. Well, we've got good news. It's actually, as Elisabetta showed you, it's actually not that much money if you think 350 euros to have your design right protected in the whole of the EU. And at national level, it'll obviously be a lot less. But what we also have at the EUIPO, and we did a pilot it's been going since 2021 when we did a pilot, we have what we call an SME fund. And now this fund opened up just in February, and it will close when the money runs out, basically. So it's first come, first served basis. And it's still open now, but you should really, it's become quite well known. So the sooner you look into it, the better. We'll pass you a link afterwards. So far, over 70,000 SMEs or businesses have been financially supported. That means you get your money back, returned part of it. And we've refunded, reimbursed over 50 million. This is actually been developed. It's actually an initiative of the Commission, and we are the office that helped to implement it. Now, what is of relevance for today is designs, and the SME Fund does cover designs. And with this fund, you can get up a 75% reimbursement on designs at national, regional, and EU level, and up to 50% at international level. And each person that applies for the fund can get a maximum of 700 euros back reimbursed. So translated, this means if at EU level a design costs 350, a basic design, if you're reimbursed 75%, that means it will end up costing you just under 90 euros, 87.5 euros. So it is really worth it to think about. And the thing is, what you have to do, there's some things that you have to take into account when you use this fund. So first of all, you have to register at our website, and then you have to apply to receive the fund. If they give the okay that you can have the fund, then you have to apply, in this case for your design, and then you have to apply for it to be refunded, for this part of the money to be refunded. So don't register first. First you apply for the fund, and then you register your design. But we'll put in the chat. I just sent before to Marta. We'll put into the chat the page of frequent asked questions, and there you can have then you should be able to, any doubts that you may have will be answered. Yeah.
Okay, great. Yeah, actually, we have already put it in the chat, so you can already all see there the link that Susanne was talking about. And we have received lots of questions, so I'm going to jump just ahead so that we can cover as many as possible. Thank you, both of you, for the presentations. I think they were so clear, and thank you, Susanne, for talking about the SME fund. I think it's always great to make it easier for SMEs to register for IP. So the first question says, we are planning to launch a new product soon. How close to launch is it still safe to file a design application without risking novelty issues? So I think, I don't know, maybe Frederik, would you like to go ahead?
Sure, no problem. So so you have, if I understand the question correctly, a design of a product almost ready, and a company wants to launch it to the market. And then, of course, the very valid question is, should we apply for registration already now, or can we wait? Because you can imagine that companies are not always sure that their new product will be a commercial success, right? So if they have the opportunity, they want to test it in the market to see if it sells, basically. And then, of course, you have the issue, if you look at design protection, that you put it there on the market to test it. You haven't made the financial effort yet to register it at design, but then you have the risk that you damage yourself the novelty condition we talked about before, right? So what we haven't mentioned yet is that there is a so-called grace period, which is there at the EU in most countries. Elisabetta, correct me if I'm wrong, but in the EU, the grace period is 12 months. So starting from the moment you make your new product, your design public, right? And so that means that you can go, for example, to a trade fair, as mentioned before, showcase your new product there, see if it has attraction, success or not. And if it has success, then you can still, up to 12 months later, apply for design registration, right? Just be aware, for example, if I'm not mistaken, for example, in China, this grace period is limited to 6 months. So you have to be aware that it's not the same grace period in all countries. But so that's something good, I think, to keep in mind.
Yeah, that's great to know, actually. Okay, so the next question says, can digital design files meant for 3D printing be protected under the new framework? And how would that work in practice? So I guess, Elisabetta, maybe this one is for you.
Yes, sure. Thank you, Marta. The answer is, in general, yes. But we have to remember that when we talk about designs, that we always talk about the appearance of something. So you can protect the appearance of a product, as we said earlier, which should be, could be, I mean, a physical object, but also a virtual product. So if this files include a representation of the design, even if it's in a virtual format, fine. There are no differences between type of designs. But if you just have the source code, so we can't see the representation of the design, so in that case, no, because design is the appearance. And then, yes, they can be registered just like any other design. And at the moment, we are working actually on the means of representation, and we still don't know if we will allow videos, for example, if we include a limited number of views. We are discussing all these issues also with the member states, because as I mentioned during the presentation, we want harmonization and also make the system very user-friendly for the users. So if they want to file a design at the EUIPO, and supposing that we allow videos, no, they should be able to use the same application also for priority purpose in any other IP office. So this is why this is taking some time, but we need to be sure that harmonization is in place here.
Okay, I see. And another question says, when does it make sense to rely on unregistered design rights versus investing in a registered design? Who would like to answer to this one?
Can briefly start if you want. Elisabetta, just continue if you like. Yeah, unregistered designs. It's, to my knowledge, not something that is known in every country, but it is quite typical for the EU. We have mentioned it in the presentation, indeed. An unregistered design is only valid for 3 years, and then that's it. So it's already limited in time. And it's also good to know that it is limited in scope of protection, in the sense that whereas, as Elisabetta mentioned, you can think about acting against identical copies, but also against variations, right? That's something you can do with a registered design. But an unregistered design, scope of protection is limited to identical or quasi-identical copies. So when should you look at that? I would basically always recommend, as Suzanne did as well, to look at registration, registered design. But you can imagine, depending on your type of product or the type of market you're in, if you have fast-moving consumer goods, for example, that it doesn't always make sense to register every type of new product, for example, in clothing you have. And then you can think, okay, I'm not going to make the investment for every single product I have, but I can still have a fallback position, if you like, and rely on unregistered designs.
I don't have anything to add because you've been extremely complete.
Perfect.
Okay, great. Yes, if at any point the other one would like to add anything, please go ahead. There is another question that might go to Elisabetta. It says, are there evolutions in ways some elements of design can be protected, like colors, textures, photos, etc.?
This is strictly related with what I was mentioning earlier. What we want to do, what we are trying to do, is to make sure that whatever is in mind of the designer is reflected in the application for registration. Because ultimately, what is protected, what you get protection for what you manage to represent in your application for registration. So it's important that we provide the tools. In terms of colors, it was already there. Shapes was already there. Lines, it was there. What changed? If you want to show the movement of these things, no? So in that case, you need the new system. And now it's something that you can do. Will we allow to file videos, which is the preferred options? I can't say anything at the moment because still there are working groups and virtual communities going on. So we will reveal everything. And as I show with the timeline, something will enter into force next month, something else at the in July next year. So the representation issues will enter into force in July 2026. So we are working hard at the moment because we have to be ready by July next year.
Okay, I see. There is another question related with the SME fund. It says, I have already registered my design. May I apply for the fund? Or, yeah, like, I'm not sure. Maybe, Suzanne, would you like to give it a try?
If you've already registered your design, no, you can't apply for the fund for that design. You could apply for the fund if you want to register a new design. First, you have to apply for the fund, then for the design.
Okay, this is something very important to remember. Okay, great. I'm just gonna go ahead and jump to the next question because we have a lot. It says, how can we monitor new design applications by our competitors? And what should we do if we spot something suspicious? So who would like to answer?
I can jump in if you want. Yeah, monitoring designs, it's not an easy one. For example, if I make the comparison with trademarks, and there you have for designs as well, you have a paying services, let's say, by private companies, let's say specialized companies that monitor the registers, EU or other countries, for new applications, for trademarks, for designs, and give you a notice if there's something new that could infringe your prior rights, right? So, but that's a paying service, which in my experience works well for trademarks, but it's a bit more difficult for designs because how you can go really far in this, and where is the limit, you know, for designs, how close is it to your product and so on. So you could take that route or consider it such a paying trademark, I should say design watch service, right? But my advice on top of that would be, I think companies know their own products and their own sector best, right? So go out there, talk to your competitors, go to trade fairs and so on, and also educate, train your people, your employees about IP rights, about design protection, so they go out there trying to sell your products, go to competitors that they can detect and spot possible infringements and notify it to you.
Okay, I'm gonna follow up with another question that it's a little bit related. I'm gonna merge two questions. It says, let's say someone starts copying my design. What's the best first step? Should I try mediation, send a cease and desist letter, or go straight to court? And there is another question that says, can the SME fund be used for IP enforcement purposes? So I'm pretty sure the second one, the answer is no, probably Suzanne.
The answer is yes.
Yes? Oh, great, that's great. I had no
Yes.
idea that the SME fund could be used for enforcement.
Yes, it was something that was introduced this year, but I have to check to see because I'm not sure because the IP scan is actually organized by vouchers. And so each voucher has its amount of money, and some of the vouchers have closed. I'm not sure. I'd have to check if this one is still open, but yes, it is included. Let me check. You can find this information in our website as well.
If you want, in the
So
meantime,
the IP scan is yeah. So IP scan enforcement is covered at national level with up to a 90% reimbursement. Up to a top value of 1,350 euros. So when you go into our SME fund area, you can see which are the participating countries for this.
okay, perfect. Great. Thank you so much, Susan. And regarding the first part of the question, what shall they do if suddenly there is a competitor copying a design?
Elisabetta, if I want to jump in, but I can go ahead if you want. I think so. The first part of the question is if you notice a potential infringement, what should I do, right? I think don't panic at first. That's always good advice. And look at what is the other party doing? How is their design looking like? What do I have in terms of IP rights, in terms of design registrations or not? And how close are things to mine, to my product, to my design, right? So first analyze the situation, right? If you don't have the knowledge of the tools, let's say, to make that analysis, you can always call upon an IP expert, a lawyer, an attorney, who can assist you in that. Quite often that can bring a cost with it, of course, but that cost can be limited just to have the first analysis, first advice, to at least know your position, right? If you then already know, okay, I can't do anything about it, then the cost stops there, and you know, okay, I can leave it there. But if you know, okay, I have a good position, I can go ahead. I'm always quite often in favor of looking for an amicable settlement. Right, trying to reach out to the other side. Perhaps they are in good faith, they didn't know. It's always possible. And I often say, I was mentioning earlier that, as Elisabetta said as well, when you file for design registration, the conditions are not checked, right? So you have, as Elisabetta showed very quickly, your design registration, and you have something in hand to send a cease and desist letter to the other side, right? And you can show on paper, I have this design registration. And as I often say, barking can be enough without biting, right? So you, barking being sending the cease and desist letter or the notice letter without going to court, without having to bite, because as we all know, going to court can be quite costly. The outcome can be uncertain. So often, not always, but often I would say that is the last step you take.
We totally
Okay.
agree with you, Frederik, and with the strategy. Perhaps, and as you said, the court should be the last forum, and perhaps something similar, let's say, but much cheaper, is coming to the EUIPO and filing invalidity application against a contested design. So this is when having a registered design really pays, because you have a registration. So it's very easy. You come to the EUIPO, and if we see a registration, that it's the moment when really the invalidity application is successful.
Mm-hmm.
Yeah.
Great. Yeah, that's really good advice. Okay, the next question says, regarding the new D symbol mentioned in the reform by Elisabetta, can that be used for unregistered designs too?
Well, I will take this one. And the answer is no, because that is a symbol that we can use for registered designs. So it shows basically that the product has a design which has been registered, no? And this is to make awareness. So another thing that maybe it's important to say here is that the office will not be responsible in the way in which this symbol is going to be used. So we provide the registrations, then the owners of the designs have something that they can put into their products, but then how they use it, if they use it in a fair way, it's not something that we can control. So this is to clarify.
Elisabetta, sorry, Marta,
Yes.
can I just ask, in the design reform, are there any sanctions if you use the new symbol without registration?
No.
Or no?
There is nothing. There is just this mention that there is this new symbol. And then I think that there is nothing in the regulation, because exactly we are not responsible on the way in which it is used.
Yeah. Okay, thanks.
No problem.
Okay, great. There is another question that you might have already answered, but just in case, here it goes. Does the design reform touch on sound or multimedia elements? Like if a sound is embedded in the visual design, could that be protected too?
I will reply immediately to this one. No. The answer is no. Let's remember always that design is appearance. So anything related with the site, it can be registered, but all the rest is out. So no sounds.
Okay, that makes sense. Okay, the next one says, does an EU registered community design protect us outside the EU? And do we need to consider filling in other key markets? Yes, Ferrari?
Yeah, sure. I'll take it. I think the short answer is, again, no. as Elisabetta showed on the map as well in the presentation, if you file for an EU design registration, you have coverage for the 27 EU member states, but that's where it stops, right? So if you're active or plan to be active in other markets, in other countries, US, China, whatever, think about registering your design there as well in time, indeed, because we already mentioned the grace periods that can be useful when you go to other countries, but don't wait too long. So it's always important, I think, to start registering in your home country and or the EU by extension. But if you have other plans abroad, let's say outside of the EU, think about that as well.
Okay, thank you so much for clarifying. And here's an interesting question. It says, can I make changes to my design after it's already been registered?
I can take this one.
Right.
Because this is something that is going to change with the legal reform, but not now, in phase 2, as from July 2026. Basically, this is something that has changed to align also with trademarks. You can't completely change the representation of your designs. So, for example, if you have filed a yellow taxi, then you can't change it, the representation, and file a bicycle, because that would be a different design. But it is possible to make very small amendment, both pre-registration and post-registration. The wording is in immaterial details. Now, it's very complicated to explain what immaterial details are. It's something minor, something that is almost imperceptible, let's say. But still, it is a possibility that up to now wasn't possible. So basically, yes, it's something that it will be possible, but for small changes that don't alter the representation of the design. And it is subject to the payment of a fee, of course.
Okay, okay. Okay, that's great to know. And there is another question. There are so many questions coming in. So here's one that I think is very interesting. If a product design evolves over time, just a small tweaks here and there, can I register those updates as a new design to maintain protection beyond 25 years? So who would like to answer to this one?
I think we both can, Elisabetta. Maybe I'll just start by saying, yeah, that's a really difficult one, and it's a challenge for quite some companies. I can give you the example of Porsche, for example, the car. I think most people know the 911 model of Porsche, and they had issues with this in the past because this type of car evolves, and it's always quite close to the previous model, right? But they want to have sufficient protection, obviously. But they had issues because they were registering designs of new models that were too close to the previous one, and then they invalidate their own protection, right? So it's so the advice I would give here is have a really good think about this, have a good strategy for your protection, for your registration. Have sufficient assistance by experts if needed, so that you have the good balance between protection but not going too close to your own designs and your own models. It's a tricky balance.
I totally agree. I support what you said. It's important to have a good strategy because it's terrible when you have invalidity applications also at the office, when you have to invalidate a design by the previous design of the same owner. So it's like you are punishing designers in a way, but this is the system is designed not to last longer than 25 years to avoid monopolies. So it's a good balance in a way. So yeah. Strategy, as Frederik said.
Exactly. It's like trying to trick a little bit the system. But okay, great. And here's a question that it's a little bit broad, but let's see your thoughts. It says, can you shed your thought on the impact of AI on design framework?
if you want, I can give a try.
Okay.
Well, AI is out from the new regulation. And you can ask also why it's out if now everyone talks about AI. But if you think when this reform started, it was in 2014 when the Commission started to think if it was important to revisit and rethink and check if the system was working properly or not. In 2014, we didn't have AI. In 2014, the main issue was 3D printing that it's in the regulation. So all these things are coming now. It doesn't mean that we're not thinking about AI, because still we need to finish all this package of the legal reform in July next year. So we are already thinking about some things like what do we do with a design produced by AI, because AI is everywhere. It's not just in the representation of designs, but in everything that moves around. So we are coming up with some guidelines. There is, again, a working group of the office working specifically on AI and on this. And I hope we can say more for phase 2. So if we will organize a new webinar, we will provide all the updates that unfortunately we are not able to reveal at the moment.
Yeah. I mean, you will have to definitely come again to give us an update in a few months. So I'm afraid we have reached the time very quickly. We still have a few more questions, but we will have to leave it here. And thank you so much, the three of you, for sharing your expertise and your knowledge with us. We could go on and on, for real. Like, I have really enjoyed this webinar. And before we go, I just want to mention a few things. First of all, that the recording of today's webinar, together with the slides, will be made available on our website tomorrow. And thank you so much as well to our audience for being so interactive and participating so much. You will receive a 2-minute survey asking, if you like the webinar and if you have any other topics that you would like us to cover in future webinars. And finally, you can see on your screen that we already have the upcoming webinar ready. So this one is going to be about digitalize IP content in the metaverse, fair use or infringement. So it's also going to be really interesting. You can use the QR code on your screen, or you can go to our website and you will find it under webinars. And that's all. Thank you so much, everyone, and have a lovely day. Bye-bye.